Hi, everybody. I'm Samantha from the law offices of Samantha Wolfe. We're located at 20 East 6th Street in Suite 206 in Waynesboro, Pennsylvania. You can reach us at 717-655-2676. And we always offer consultations. Part of the reason we do that is because we like to give clients or potential clients information that they might be seeking. And part of that is why we do our monthly virtual seminars. So this is our second month back. We did take the summer off. And what we're going to try to do over our next couple of seminars is give specific examples based on some of our client situations about ways that we're able to do some planning. So today we're going to talk a lot about parental control, and if you want to be able to have control after you've passed away, how we're able to do that. So with that being said, let's go ahead and get started. So this is our office building, so you can come visit us at any time. We're on the second floor, right off the elevator. Then we have our mission statement. We always open with that because I think it's important for clients to know where we're coming from and kind of what direction we want to go. So part of that, like I said, is the education. So today we're going to talk about I love my kids, but, and then parental control after death. So let's dive in. I have some good examples that we'll go over. So know that here at our office, one of our philosophies is that we do always want to keep the estate plan as simple as we can make it while still accomplishing a client's goals. So a lot of times a typical estate plan is a will-based plan that distributes assets after somebody's passed away, and it'll go outright free of trust to those beneficiaries. And a lot of times it might go to the spouse, if the spouse survives, and then on to the children. So that's a typical estate plan. And then the problem with that is that if it goes outright to a child, then once they receive it, it's considered part of their estate. And then you don't really have the control after you pass away. So that being said, if you have a child, for example, that has some spending issues, if you have a child where maybe you don't care for the spouse and it goes outright to them, the issue then is if they pass away, then it goes according to their estate plan if they have one. Otherwise, Pennsylvania or wherever state they're living in would kind of dictate their estate plan. So when we're talking to a mom and dad or a husband and wife, sometimes they don't like that they can't control, protect, kind of isolate that inheritance from any type of creditor. And we're talking about creditors. We're talking about everything from if your child would get in a car accident, it could be a divorce, it could be certain spending habits. It could be that they might be on public benefits. So we certainly have some clients here on SSI and SSDI. And if mom and dad left their entire inheritance to that child outright, then it would be problematic for those government benefits. So even though a typical estate plan is a will-based plan, our job is to educate clients as well as our referral sources about other options that might accomplish the goal better for the client. So I would say that when we're meeting with clients, we're still seeing a big portion of our clients do a will-based plan, but we are seeing that transition a little bit. And how we're transitioning that is we're using trusts. So we're going to go over all the different types of trust and how they work, but I wanted to talk about a trust versus no trust. So if somebody comes in and they say, hey, I want to trust, this is what I want to accomplish with that, then we'll certainly explore all of those options. But one thing I wanted everybody to know is if the reason that you are thinking, hey, I want to have some sort of parental control, or even for grandparents, if they want to have some sort of control for those grandkids, it might simply be because those beneficiaries are underage. So if they're under the age of 18, then in Pennsylvania, you have to have some sort of custodian or guardian who receives those funds. So just know that in Pennsylvania, we have what's called Uniform Transfers to Minor Act. We call that the UTMA Act. And this is a clause that you can include in your last will and testament. And in Pennsylvania, you can name a custodian for someone up until age 25. Now, past 25, then you are looking at a trust as the way in which you can protect those assets. But if someone is 21, 18, 16, or even younger, you can use an UTMA clause. So if you're simply thinking, well, this child is underage, then an UTMA clause might be all you need in the will. And so when we're dealing with young parents who have young kids, often an UTMA clause will accomplish what they want. Second thing I wanted to go over is that sometimes we're in situations where we have a child or a grandchild, and maybe there are some special needs in that situation, but we don't know that they're actually qualified for government benefits, or they haven't qualified yet. Might be age, it might be because of their means, but there's a potential that that beneficiary might qualify for benefits in the future. Or if it's something where you have grandkids and you're leaving a certain amount to them, but you don't know, if you survive 15 years after the will, then we don't need the UTMA clause. So in our wills, we do recommend that we include a clause that grants the executor or the personal representative the ability to create a trust for that beneficiary if the beneficiary is minor or has a legal disability. And so that's something where you're giving that power to the executor or the personal representative, meaning that you aren't creating a trust at the time you establish the will, but you are giving the executor the ability to create that trust in the future. And this we've actually used more than I thought we ever would when we use this language in our wills. We just had a situation where somebody passed away, and it was their grandchild who was one of the residuary beneficiaries. And that child was having some spending issues and some spending concerns, as well as a significant other in their life where the executor thought there might be some negative influences happening with spending habits. And so in that case, we talked to the executor. We said, well, we do have this provision in the will, so you can create a trust for the benefit of that individual. So they're still receiving their full inheritance, but it's going in trust for them. So again, the trust isn't set up at the time our client would create the will. It would be something the executor sets up after the fact if the circumstances would warrant that. So I wanted to make sure that you knew that. So those of you who are on the call who are existing clients, know that your will does have that provision in there. If it's something where you're listening and we haven't met yet, or you're a referral source, then know that we always recommend to include that clause in there, just so that we can ensure that it gives the executor flexibility when our client would pass away. And then lastly, I wanted to touch on standby guardianship forms. So I've talked about this in other seminars. And for those of you who don't know, we do have a YouTube channel where we post all of our seminars along with short videos that we may have recorded talking about certain topics. So we do have an entire seminar where we've talked about if you're a younger couple planning, what does your estate plan need to look like? And one of the components of that is a standby guardianship form. So in the will, if you have underage kids, you typically are going to name the permanent guardian for those children if you would pass away or you and your spouse would pass away. But a standby guardianship form is something where if you and your spouse are traveling for a short period of time, and maybe your children are staying with somebody who's not the permanent guardian under the will, but is somebody that if something would happen to the kids and they couldn't get a hold of you, you'd be okay with them taking them to the emergency room and getting treatment for whatever that child would need. Standby guardianship form is something Pennsylvania allows for a short period of time for whoever is caring for those children to be able to consent to certain legal things and certain medical treatments. So I wanted to make sure people knew about the standby guardianship form. What we do is when we're doing planning for families that have younger children, we give them a PDF that they can just print off and use as they need to. Now we're going to get into kind of the fun part of the presentation. I'm really excited about what we're going to go over because I think examples are the best way to explain something, at least in my opinion. So we're going to talk a lot about trust today and how we use trust to create control or create an environment in which we're protecting the beneficiaries under our will or under our estate plan. So I wanted to just lay the foundation for what a trust is. So trust is really just a document that kind of outlines a set of rules that you want that asset to be bound by. So it might be real estate, it might be a bank account. And if you retitle it, whatever that trust name is, then it's bound by those written rules that you've put in the trust instrument. And so it can be really flexible and offer a lot of different options, or it can also create restrictions on certain family members depending on what you want to do. So just know that a trust is just a written document that our office or any other attorney would draft based on what you say you would want those transfer restrictions or what you would want those control mechanisms to be. So the purpose of a trust is traditionally used, and when I say traditionally, I'm thinking of like what most people think of a trust. It's usually used to minimize estate taxes and maybe offer other benefits, usually kind of revolving around taxes. That's historically what trusts have been used for. But in recent years, we've realized that trusts can do a lot more. And so know that even though trusts do offer a lot of tax benefits, and we'll talk a little bit about those tax benefits, also know that predominantly trusts are being used as protective measures now and not so much for minimization of taxes. And that's just because the federal estate tax exemption is so high currently that most people aren't worried about the federal estate tax. They're more worried about how do we protect these assets for future generations. So saying you have a trust is a lot like saying you have a car. And you can have all kinds of features. You can tailor it however you want, just like you can for a car. But let's go over the main categories of trust that we have. So we have a revocable trust. And we're going to see some examples where we use revocable trust for clients. But a revocable trust is typically called a living trust. And I always think that's a little bit of a misconception, because know that irrevocable trust can also be living trust, because it's all about, when we're talking about a living trust, it means that you created it while you were living. So you can have a living revocable trust. You can also have a living irrevocable trust. But usually, if you would jump on Google and type in revocable trust, it's going to be called a living trust. And usually what this type of trust is used for is to avoid probate, because the person who creates it, if we have a husband and wife and they create a revocable trust and then fund assets into the trust, then when one or both of them pass away, if those assets are owned by the trust, then those assets don't have to go through the probate process to be transferred to the next generation. Probate process is just the process by which somebody is appointed as the executor and is given legal authority to transfer all of the assets and distribute them among the beneficiaries according to the last will and testament. Probate in Pennsylvania doesn't cost a lot from a filing standpoint, but know that really what kind of cost is all the other things that either you or you hire your attorney to do. You typically have to advertise, you have to give notice to certain individuals, you have to file certain returns. There's a lot of little paperwork things that have to be filed along the way. So revocable trusts do avoid the probate process. And instead what happens is when the grantor, that's the person who creates the trust, when they pass away, they distribute the assets according to what the trust document says. And there's not as much court involvement. There's not as much filing that has to be done. So it kind of streamlines the process and cuts down on legal fees as far as cost of administration. So we have a lot of clients who are interested in that. And we also have a lot of clients, because we're right on the Pennsylvania-Maryland border. So we have some clients who might live in Pennsylvania but have assets in Maryland, or they might live in Pennsylvania but winter in Florida. And so a lot of times revocable trusts are really helpful if you have assets in multiple states, because it streamlines the probate process. Otherwise, you'd have to do some sort of probate documentation in those different states. And so a revocable trust can streamline that. When it comes to parental controls, though, a revocable trust can set up a structure, and there's a specific example that I'm going to show you with this, can set up a structure where rather than it paying outright to all of your kids, it can go in trust to them. And the benefit is that it's revocable. You can add, remove beneficiaries, change what happens at your death at any time. So revocable trust can be used in the context of providing parental control. We have a specific example in a couple of slides to show you that. The second category of trusts are irrevocable trusts. And these are the most common trusts that are misconstrued or misunderstood. So if you type in your Google search an irrevocable trust, a lot of times you're going to see all kinds of things about how your control is limited, how you can't do certain things, about how you can't be the trustee. And so again, those are the traditional ways that we thought of irrevocable trusts. But now that we're not trying to do certain tax things for a lot of people, we kind of can use an irrevocable trust, give you more power and more access, and still get the protective measures. So we use this type of trust usually for like long-term care. We might do it for certain gifting. We do have some specific examples for you there. But generally, how an irrevocable trust is that husband and wife or husband, wife, whoever creates it and they fund it. And typically how it would work is that you wouldn't be able to change certain terms of it, or you wouldn't be able to pull those assets out. That's generally how irrevocable trusts are thought of. Like I said, we're going to give some examples that show that that's not always the case. Third category are asset protection trusts. So sometimes they're called APT trusts, asset protection trusts, and that's just to shield the grantor against future creditor claims. So it's using an irrevocable trust and kind of repurposing it for the creditor protection. We have some examples using asset protection trusts. And then finally, the last trust I wanted to cover is a charitable trust. Charitable trust is typically an irrevocable trust that's established and it has some sort of charitable purpose or intent. So it might be a certain percent goes to charity. It might be when a certain beneficiary passes away, it goes to charity. A lot of times these are used so that you can get some income tax deductions or so that you can get some federal estate tax deductions. So I wanted to make sure to mention charitable trusts. Okay, I'm looking to my right because my sister is in here helping me do the presentation and she loves this picture. So I based this example on my own family and I pulled from my mom's photo albums, Christmas morning of 1987. And just to have a little fun, I want to point out that my sister that I'm talking about is the one in the middle at the bottom making that horrible expression. So she loves this picture. I'm the one off to the left that has that weird smirk on my face. But this was Christmas morning for us in 1987. I had 3 sisters. My parents have 4 girls. So we're going to talk about a situation that would be based on mom and dad. So let's give some facts. So know that this is a little bit different from what mom and dad, but it kind of represents a family where there's a long-standing marriage. So mom and dad, my parents are both in their early 60s. They've been married for over 41 years. There are 4 of us. All 3 of my sisters are married. I am not. And then my one niece, so their one granddaughter, Audrey, she has special needs. And so let's talk about what their concerns are. So first, know that they have a primary residence that's jointly owned between husband and wife. So when we did the initial consultation, this is where husband and wife say, yes, both of our names are on the deed. We have a bank account, both of their names are on that. We have an investment account that's jointly owned. We have an investment account that's just in wife's name. Then each of them have a retirement account. Okay, so you're looking at husband and wife have usually in this situation where we're talking about between 1 and 3 million. Okay. And their concerns are, of course, their unknown future spouse. In this case, it would be for me. They're concerned about Audrey, who has special needs, and what if they would leave something for her. And they're also worried about long-term care as they age. So I would say usually folks that have a net worth of between 500,000, it could be lower too. You know, we go all the way down to 200, 300,000, all the way up to about 3 million. Those are generally kind of the range of people that are worried about long-term care costs. So let's look at kind of their plan and know that this looks, I know, a little overwhelming, but we're going to break it down. So this kind of shows the overall plan that we did for my parents. So know that they do still have a will, a last will and testament. Their will just says that they're leaving everything to each other. And then upon the death of the second spouse, it just goes equally to their 4 daughters. But know that there's not going to be a whole lot that goes through their will, because when we go back to the previous slide and we look at their assets, we're going to put on the far right, you're going to see the column there about what we're doing with those assets. So we're going to transfer their house into trust. We're going to transfer their one investment account into the trust. We're going to add my dad's name to my mom's investment account. And then we're going to designate the trust as the beneficiary for IRA. So what that means is that there probably won't be a lot of assets that go through probate. And remember, the will just says how the probate assets are distributed. So even though mom and dad have a will, it's not as important as these other documents. So what we recommended and what we did for my parents is we used certain trust to protect assets because one of their concerns was long-term care costs. So this is their total estate plan, but I want to break it down. So let's take it trust by trust. So this one, their income only trust. So, how it works is mom and dad, Denny and Denise, can be the trustee, which means that they can choose to invest any of the assets owned in the trust. So, let's say that they put their investment account in there. They're still working with the financial advisor about how to invest those assets. They can buy and sell anything inside the trust because, as the trustee, that's their role. Okay. So, know that in Pennsylvania, if mom and dad had the power of distribution that normally the trustee has, then it would be available for their long-term care costs. So instead, what we've done in this trust is we've said, okay, the power of distribution that would make it so these assets are available for creditors, the biggest being a nursing home, we're going to give this to somebody we're going to call the trust protector. And you're going to see that the trust protector in this case is my sister Jessica. And her job is if anything needs to be pulled out of the trust, she can reach in and pull it out. Okay. That means that those assets are protected against mom and dad's creditors, the biggest creditor being a nursing home, once the assets have been owned in this trust for 5 years or longer. So my parents are at the perfect age to do this type of planning because the goal is they'll survive the 5 years, and then anything owned in this trust is not available for nursing home costs. Now, you're also going to see that it says income beneficiary and it has Dennis, Denise, and children. So, what that means is if my mom and dad transfer that investment account into this and that investment account generates interest or dividends, they can still receive those interest or dividends. If they want to touch the principal of it, so let's say that investment account, Jess, can you go back? Let's just look at what the total was. So the investment account that we're transferring into the trust has about 275,000. So let's say once we transfer it into the trust, it generates $2,000 worth of interest in a year. Mom and dad, as the trustees, would be able to withdraw the interest and dividends themselves without having my sister Jessica as a trust protector pull it out. Okay. But if they wanted to pull out any of the 275,000, they would just go to Jess and ask her to make a distribution out of the trust. Now, this is an irrevocable trust. So normally it would make people uncomfortable because they would say, well, we don't have control over those assets once we transfer it in. But what we did with this trust is we gave mom and dad the ability to fire Jess if she doesn't do what they're asking her to do. So for example, if they want to receive 100,000 out of the trust because they want to go on a really nice vacation, and of course, they're going to take all of us. So they're asking for a distribution out of it. So in that case, if they go to Jess and ask her to make the distribution of 100,000 and Jess tells them no, they can actually fire her and appoint somebody else to do that. So even though mom and dad can't reach in and pull out those assets, and remember, this is just the principal because they can pull the interest and dividends generated every year, but they can't pull the principal without the assistance of the trust protector. So if the trust protector doesn't do what they're asking, they can fire her and appoint somebody else. The other thing to know is that even though this is an irrevocable trust, mom and dad have the ability to add and remove beneficiaries at any time. So if for some reason I marry somebody they don't like and they want to completely disinherit me from receiving assets out of this trust, they can remove me as a beneficiary and they can also add any beneficiaries. So if at any point in time they want to add the grandkids on as beneficiaries, they can do that. So even though it's an irrevocable trust, you still have so much control over the assets inside this trust. And I wanted to use my parents as an example because often when I meet with clients, they don't understand that there are these opportunities and protective measures that protect their assets against long-term care costs. They just think if it has to be an irrevocable trust, then they've given up all rights and control. And that's not the case in this trust. You can even terminate irrevocable trust in Pennsylvania if you have the beneficiaries agree to that. So think about this. If they wanted to get rid of the trust completely, they just need our 4 signatures because we're the beneficiaries of the trust, my sisters and I. But if I say no, they can remove me as a beneficiary and just have my 3 sisters sign. So I wanted to use this as an example because I think that it really drives home the point that we need to be looking and discussing these irrevocable trusts if we're talking about creditor protection, not just for the next generation, because we're going to talk about that in a second, but even for the client themselves to protect against long-term care costs. A couple of things I highlighted on the visual that I want to go over. So the first is, remember Audrey, my niece, has special needs. Audrey is Krista's daughter. And so how we have it is that if something would happen to Krista, it goes per stirpe. That means it goes to her children equally. It doesn't go to her spouse. It goes to her children. And then what would happen is my sisters and I would all serve as the trustees for our niece and nephew. And in this case, the trustee can convert any child share to a supplemental needs trust. So if something happens to Krista and there's assets left in her trust, what we would do is we'd convert that to a special needs trust for Audrey. And then she would be able to qualify for whatever benefits she either is already receiving or could receive in the future, and that inheritance will not jeopardize that. So I wanted to make sure to give you an example of this. So we didn't create a supplemental needs trust or a special needs trust for Audrey. We didn't need to, but we're giving the trustee the ability to create it if they would need to do that. The other thing I wanted to mention is that for the most part, depending on the day, but for the most part, mom and dad like their son-in-laws. So there's always a question of, do you want it to go to a spouse? So in this case, my parents decided that they did not want it to go to any in-laws. So it's going to go to each daughter's children to the extent they have any. I don't have any children. So what mom and dad did there is they said, well, if she passes away and doesn't have any children, her share goes back equally to her surviving siblings. So my 3 sisters would get my 4th shared equally among them. The other thing they could have done is they could have said, well, that's going to go to grandchildren. So they could have said my 4th can go on to grandchildren. The difference is that if I had received my 25% outright and then I passed away, it's going to go according to my estate plan. So if I wanted to leave money to a significant other, a boyfriend, then they can't control that. But here, because it's going in trust for me, if I would pass away, my share is going back where my parents wanted to go. And so I wanted to point that out. The other thing is, let's say my parents did not like one of their son-in-laws. The other thing here is it's not going to a spouse. So again, if, for example, my sister Jess passed away, her estate plan leaves everything to her husband. But my parents don't necessarily want it to go to her husband, even though they adore him. They may want it to go to their grandkids. And so that's the other beautiful thing about using a trust is you can say it's going to those grandchildren. So I wanted to point that out. The last thing I wanted to point out about what my parents did as part of their estate plan that some people ask about is that if there's real estate, like a family home involved, and they say, well, we want it to go equally among all of our kids. So in this case, we each get a 1/4 share. But if I wanted to sell my 1/4 share, I would first have to offer it to my sister's other separate trust shares. And you can even stipulate the value in here. It's for the appraised value, but you could set the value amount or create a formula in which those other siblings could buy it out. Now, my parents didn't say that we had to keep the house. So if the trustee would decide that they're going to sell the house when my parents pass away and divide all the sale proceeds, it just means that everybody's share of the sale proceeds goes in trust. But if we decide to hang on to the house and somebody wants to sell their share, it gives them the ability to sell it to their other siblings. So I wanted to point out that. So that's one part of their plan. Then we did 2 other trusts, one for the primary residence, because even though a primary residence is exempt against nursing home costs, they can put the nursing home through the Department of Human Services can put a Medicaid recovery lien against the house. So by transferring into the trust, what my parents are ensuring is that even if they use all of their funds, which we want them to live life the way they want to, but let's just say that they use all of their other funds, then the value of the house is guaranteed to go into the next generation. So at least that asset will be preserved. If it went through the will, then it would be subject to any nursing homes coming back at death against this. So by putting it in trust, we're preserving the value. The other thing is if mom or dad needed nursing home care and the house had to be sold, if it's in trust, it protects those sale proceeds. So in the situation of my dad would need to go into a nursing home, the sale proceeds could be used for mom as she lives in the community, whether assisted living or she's still at home. So it gives that option. And then the other trust that we had was the Wolfe Protector Trust. This could be for life insurance. So, for example, life insurance, if it has a cash value, that's available for a nursing home. So sometimes we'll throw ownership of a life insurance into a trust. It can own any investment account where you don't want to have access to the interest and dividends. So in our example, the $275,000 that we transferred into the income trust, we could put into this protector trust. The difference would be that my mom and dad wouldn't be able to withdraw the interest and dividends without Jeff doing that for them. So it's just what level of protection. So it gave my parents a lot of different options, and then we were able to protect the asset. The other thing I wanted to mention is that both my parents do have retirement accounts. And if my dad goes into a nursing home, his retirement's available to pay for his care, but it's not available for my mom's care. But if he dies and my mom is the primary beneficiary, then something that wasn't originally available for my mom's care becomes available for her care when my dad dies. So sometimes we'll designate the trust as the primary beneficiary of retirement accounts. The spouse is the contingent beneficiary, because then that gives us the option to protect it if we need to against long-term care costs. If the spouse isn't in a nursing home, they as the trustee can just claim and it would pay to them outright as the surviving spouse. So it gives us a lot of options. So we're talking about parental control. What this did for my parents is it protects the assets against their own long-term care costs. Plus it sets it up so that each of my sister and I's shares is protected against our creditors, as well as if it goes to the grandkids, my niece's share can be switched to a supplemental niece trust and give her the protection she needs. So that's our first example. Second example is the Casper family. And this, again, we just pulled some facts from different families that we have, and we wanted to give this as an example. So in this case, we have David Casper. He's a widowed father of 3 children. We have Henry, Donald, and Holly. He's disinheriting his son, Henry, and he wants to provide for his 2 other children and his grandchildren. So some concerns he has are the children and grandchildren's future, and then some long-term care concerns for himself. So these are his assets. He has a primary residence. He has some additional real estate. He has an investment account, and then he has some life insurance. And the important thing to know about the life insurance is there's a cash value to it, so it's available to his creditors. So let's look at the plan that we did. And again, we're going to break it down because there's so much that we can't fit on the page. So the first thing we did is his will. So notice that we include a custodial clause. So anything passing under the will, if we're going to have it go to an underage beneficiary, and this was important because he had it some provisions for grandchildren in there. So we wanted to name a custodian. So it goes to surviving child, or then to the surviving parent if we have a beneficiary under the age of 25. And then we specifically disinherited his son Henry and Henry's descendants, although we're providing for Hank Casper with non-probate assets. So non-probate assets would be life insurance or retirement. Those would be assets that have a designated beneficiary. So it's going to go to Hank as the grandson, but it's just not going to go using probate assets. So this is what his plan looks like. So we did the Casper Farm Protector Trust. It's an income-only trust. So if he wants, and he has renters in that real estate, he can still receive the rental income off of the trust. But we'd put his real estate in here to protect it against his creditors, the biggest being a nursing home. And then what we did is, you're going to see over to the right, there's Hank Casper's Children's Trust. So the reason we did this is that David wanted it so that it goes in trust for Hank, and it's going to be a certain percentage of the beneficiary designation. So 20% of a John Hancock life insurance policy is going to pay into this trust, and it's going to stay in trust until Hank reaches age 30, and then it's going to pay outright to him. The other 80% of the life insurance is going to go into the Casper Farm Protector Trust. And then you're going to see here that upon David's death, any real estate that he owned where his children were residing, because he had multiple parcels, and a couple of those he had children that were living there paying rent. And so he was saying, well, when I die, I want that parcel to go to that specific child's separate trust share, so that they would receive that and still be able to reside there. And then the second thing he wanted to have happen is he wanted $100,000 to go to each grandchild. And you're going to see there at the bottom, each grandchild had a separate trust share. So each grandchild's going to get $100,000 put in a separate trust for them, so that way it's protected. They're underage, the grandchildren, so it's going to make sure that the trustee is his son until they reach an appropriate age. And then it would allow that grandchild to serve. You're also going to see that under the shares for Donald and Holly, we did put, if one of them wants to sell the real estate, they first have to offer it to the other. So it's just some transfer restrictions for them. So we're able to protect the assets against David's long-term care and protect it against creditors. We disinherited the child. He did not want to receive anything. We provided for his grandson that he wanted to receive 20% of the life insurance proceeds. And then we were able to protect each grandchild's share that are getting 100,000. So in this case, we were able to accomplish all that David wanted using the trust. Now remember, the 5-year look back period does apply for the farm protector trust. So the assets do have to be owned in the trust for 5 years before they're not available for his nursing home. But upon transfer into the trust, all of that real estate does now avoid probate, which means that when David passes away, a probate estate doesn't have to be open to transfer that real estate. And that's huge because his real estate was worth quite a bit. And there are 2 ways that attorneys can charge for estate administration. So the first is they can charge a percentage, and that percentage can be up to 5% depending on the value of the estate. Or if it's in a trust, they either can only charge 1% or they have to charge hourly. And so they're having to show what work they did and their earning of the fee. So we like a trust for that reason because it does limit attorneys' fees as well. And I think that's a conversation that you always need to have with your attorney is how do they handle the estate administration and what's the cost to administer the estate. So in this case, David normally, and this is just compared to what it would cost when we normally do an estate administration, with his size of the estate and what assets, it could cost up to $30,000 to administer his estate. With a trust, you're reducing that. For example, we're working on a file where we're using trusts and the attorney's fee is going to be less than $10,000. So you've saved quite a bit of money by using trusts. Now, I know that a lot of attorneys talk about avoiding probate. So again, the avoidance of probate isn't so important for the filings. It's more important because it caps attorney's fees and makes it so that it's easy to administer for the next generation. All right, let's go to our next case study. So this is the Woodsy family. So again, I wanted to think of different facts and circumstances that we knew from different clients, and this is kind of a conglomeration of all of that. So we have Jim and Shirley. They have 3 children, all of which are grown. They're married. It's a long-standing marriage, but they do not live in the same household. So, and they have multiple oil and gas interests, and they own certain properties with children that they want to go to specific children at death. So this is just a brief summary of the assets that they have. So a little bit bigger estate, and that's important because when we talk about the concerns, you're going to see they're concerned about children and grandchildren's future. They're concerned about federal estate tax planning because if the exemption does drop, which they're talking about doing, lowering it to $6 million, then we would have, some concern here, what that would mean for their estate. We want to simplify their estate plan. We want to reduce inheritance tax. So inheritance tax is 4.5% of whatever the date of death values are. So we want to reduce that. One of the sons has a drug problem, so we want to provide some protection for that. And then we want to provide a certain amount to their grandchild, Kyle, and we want to use a supplemental needs trust. So know that this isn't based entirely on one situation. We're just trying to throw some different facts in there so you can see what we're able to do with some trusts. So the first thing that we do is we do set up a revocable living trust. And the reason we do that is because in this case, we're talking about a long-standing marriage, but they're not actually living in the same house. So they're separated, for lack of a better word. And so what we don't want to have happen in this case is we don't want one of them to die and the other spouse to go and change the estate plan, which you can do just by redoing your will. So by doing a revocable living trust, what happens is when the first spouse dies, all of this becomes irrevocable and is locked in. So this way, both spouses can make sure that things are being distributed the way they had originally intended, rather than one spouse being able to change it. So I've highlighted a couple of things I wanted to point out. So the first is that you'll see under the family trust, it says that ABC Corporation goes specifically to James and Robert's separate trust shares. So that's the business that they own with their sons. So we're going to have it go equally to each of those sons' separate trust shares. You're also going to see that upon the second spouse's death, they want $400,000 to pay to their grandson Kyle's supplemental needs trust. His supplemental needs trust is just on the next slide, okay? But know that when they pass away, $400,000 is paying in there. That's because he's already on government benefits, and in this case, we don't want it to jeopardize his inheritance. We don't want that to jeopardize his government benefits. You're also going to notice that the son with a drug problem, Jeff, We're not going to have him be his own trustee. So he's going to get a third of the estate, not the corporation. He's not going to get that, but he's going to get a third of everything else. But we're not going to have him be his own trustee. We're going to have his brothers be his trustee. And it's completely discretionary, meaning that they can make a distribution for whatever he would need. But mom and dad do have a stipulation, which is that he must be clean and sober for 5 years before he can receive a distribution. So this is something that mom and dad felt really strongly about, and the trust, we were able to be really flexible and draft it to accomplish this goal. The other two sons, so James and Robert, they can serve as their own trustee. They can pull anything out for their health, education, maintenance, and support. So it's a much more flexible standard, but they don't have, mom and dad don't have the concerns about the drug problem like they do with Jeff. Okay, so we were able to protect Jeff's share. We're able to get the corporation to James and Robert the way they want to. The other thing this does, like we talked about, is it makes sure that it kind of sets in stone when we have a long-standing marriage, or this could work too if you have a blended family, if it's a second marriage. We often use revocable trust because, again, then they're irrevocable and the surviving spouse can't change the will and completely change the estate plan. So we like to use them for that. The other reason that we use this revocable trust is for federal estate tax planning. So this way, what we can do is we can always make sure that we're maximizing and doubling up the coupon, meaning that James has a certain amount he can pass free of tax, and Shirley does as well. So this makes sure that we can do that even if they would get remarried. So it accomplishes their goals of federal estate tax planning. The second aspect of their plan, we did this on a second page because we always do visuals. So this was the second page of their visuals. So the first thing I want to point out is all the way to the right, you're going to see Kyle's Supplemental Needs Trust. So the benefit there is that we're able to say that the trustee can make distributions to supplement but not supplant any benefit, and that would allow him to then still be able to receive SSI or SSDI, whatever he's receiving. So we did that. The other thing we did is that there were multiple businesses, and part of the business they wanted to go ahead and transfer to their sons. The reason they wanted to do that is because it was certain real estate that the two sons are never going to sell, and they wanted to reduce the inheritance tax. Because remember, if you have a large piece of property or any asset that's quite large, when you die, there's 4.5% inheritance tax. But in this case, what we did is we divided the properties and put them in two trusts, one for each son. And by doing that, we've gifted it to them. So if James and Shirley survive it by 1 year, there's no inheritance tax on anything that's in the two trusts, the Rolling Ridge Trust number 1 and the Rolling Ridge Trust number 2. There's no inheritance tax. So when we did this, in this situation, it would have saved James, the son, and Robert over $100,000 in inheritance tax because of the value of that property. So it's quite a bit of tax savings there. And in this case, what we're able to do is transfer it in trust so that way neither son, no spouses can attach to it, no creditors can attach to it. So it's a nice way to make sure that the gifting is happening to reduce the federal estate tax, but doing it in a way that we're protecting mom and dad so that those assets aren't subject to their children's creditors. So if one of the kids would get divorced, that real estate is not subject to that divorcing spouse. So we were able to accomplish all of the client's goals that way. So both tax as well as creditor protection. And in this case, the creditor protection was using Jeff's, can you flip back, Jeff's separate trust share? Because again, he had the drug problem. So we're protecting Jeff that way. We're also protecting the two sons' gifted real estate so that it's protected there. Also know, these trusts aren't designed to do long-term care protection, but by James and Shirley gifting it into the trust, if they survive that by 1 year, that real estate is also protected against their long-term care costs. So we're able to protect it against their nursing home costs and protect it against their son's potential creditors. So this plan, we were able to do all that they needed and accomplish that. All right, I think I have one more, I think. Isn't this fun? So case number 4, we're talking about the Case family. So let's meet the facts for this one. So we have Justin. He's a single male. He has 2 children, Jake and Laurie. One is in the military. The other is a senior in high school. He owns 2 different businesses, and he has some properties with stipulations about who can reside there. He's a longstanding landlord. He has some good tenants that he wants to make sure to provide for. And so we have a primary residence, we have different businesses, we have additional properties. So a larger estate here, over 2 million. So the concerns are that his children are younger, 21 and 17, and they're not actually part of the business yet. So he doesn't know if they're going to be part of the business or not. Second thing is he wants to ease the administration upon death, avoid probate, have a revocable living trust so that all of that probate stuff doesn't have to happen, kind of cut down on attorney's fees. And then he wants to protect his long-term companion, Jane Doe, with certain funds that would be there to provide for her, but then upon her death would go to his kids. Because if he left it outright to Jane Doe, then it would go according to her will or her estate plan. So he doesn't want to do that. So in this case, what we were able to do for Justin is we created an estate plan that looked like this. So in this case, we have a revocable living trust. He's the trustee. He's going to fund whatever assets he wants during life. We have a successor trustee listed. So upon his death, that's the person who makes sure the assets get where he wants. During his life, he's the beneficiary. He can put money in, pull money out of this trust for whatever he wants, and he can change it at any time. If he funds assets during life into the trust, the benefit is that it avoids probate, meaning when he passes away, he doesn't have to have an executor appointed. None of those probate processes have to happen in order for them to have access to these things. Upon Justin's death, it does become irrevocable, and that was important to him, so his kids didn't have a lot of changes that they could make. And then what happens is upon his death, the trustee is going to make the following specific bequests. So the first is Jane Doe is going to have a life estate in the real estate located on Main Street. Second thing is that 1,000 Mountain Road is going to be held in trust. So a Mr. Philip Taylor has the right to reside in the house and only has to pay utilities to remain living at the address. Number 3, he wants Case Construction Company to be distributed in trust as shown below. And then his second company, Professional Views Incorporated, he wanted distributed into another trust with some different terms. So let's look at what the terms say. So we have the 1,000 Mountain Road. That's the one where he has Mr. Taylor getting the right to reside there. So Mr. Taylor, in this case, he's an older gentleman, so he just wants to provide him the opportunity to live there. But then upon his death, this goes to his kids. So we're putting it in trust that way, because otherwise we'd have to do something where we deeded it and then had some sort of agreement between everybody that's a little bit harder to enforce. So in this case, we just threw it into a trust that's created upon his death specific for this property. We put the Case Construction Company into a separate trust. Trustee is going to be one of his business associates, and then the beneficiaries are his business associate and his children. Okay, so different percentages there. And then the trustee has the ability to make distributions for whatever they're able to distribute out. And the thought there was that we didn't want the kids to be pulling out all of the profits. We wanted it to be there to be able to function and have the business run. The second business, Professional Views, is in a separate trust because he had different beneficiaries. So he has his business partner and then his 2 kids, different business associate than under Case Construction. Same thing, we had his business associate as the trustee, can make distributions out for whatever is needed. And then the benefit there is if those businesses are ever sold, then they would be divided depending on how it was. So the one would be 25% to different individuals, the other would be 1/3, but Justin could decide to change that or tailor that however he wanted. And then everything else gets divided equally between his children, Jake and Laurie, and goes in trust for them. Because they're only 21 and 17, it says that his business associate, Ann, is going to be the trustee until those children attain 35, and then they could serve as their own trustee. So it just allows the protection for his kids to be able to grow up, do things that they want, but have this. The other thing I talked to Justin about was that if, for example, his son or daughter, as they got older, ever wanted to join the business, because this is a revocable trust, he can always change any aspect of this, change the provisions of the trust terms that are created when he passes away. So it's a nice way to create a fluid estate plan that gives him the protection where if he died tomorrow, his business would be protected because he does have that key employee that would be able to take over things for him. So in this case, we were able to address his concerns for his kids, protecting his kid. We're able to make sure that his longtime companion, Jane Doe, has the right to reside at the real estate. His longstanding tenant has the right to reside in the real estate. So again, we're accomplishing all of his goals, and we're able to do that using one trust document. So I know all of the different bubbles that we're showing here, that know that that's all one trust document. We're able to outline it under the same trust document. So that means that the trustee then just has to administer it according to what that trust document is without having to probate it at all. Okay. So I always want to tell people, excuse me, what assets they might want to protect. So their home, rental real estate, non-rental real estate, IRAs. Now I want to pause here because the IRAs, we want to make sure we're protecting the beneficiary. So whether it be the spouse and we want it to go in trust in case the spouse is in a nursing home, that might be one way we protect it. If it's going to children, it might be going in trust for them so that they can't liquidate all of the IRA funds and pull it out all at once. So it's not so much transferring ownership of the IRA, it's more protecting through the beneficiary designations. We can protect life insurance by transferring ownership into the trust and then also having the trust as the beneficiary so that it goes in trust for your beneficiaries. We can protect bank accounts, business interests, collectibles, any future inheritance. We can protect what assets you have and what you want to try to protect, because we can do that using a trust. And trusts are really flexible, like we talked about through these different examples. And I know I really like them a lot as use and part of an estate plan. All right, so Jess, what else we got? Our next seminar is November 10th, 2022, from noon to 1 again. And this is about living at home at 50 could be a good thing. So this, we're going to use examples about if mom and dad need nursing home care and how having an adult child, there are a lot of different exemptions that would protect assets if you have a child who's a caregiver or living with you. So we wanted to kind of explore all of that in the next seminar. So it'll be based on examples. So you can register by emailing Amy. You can also call our office, or you can register on the website. And I see that we have a chat, so let me answer this because I think this is relevant. So one of the questions was, please contrast the trust protector versus the trustee. Good question. So the trustee, let me talk about traditionally what a trustee does. So traditionally, a trustee is the person who buys and sells the assets in the trust and manages the assets. Typically, the trustee also makes distributions out of the trust to the beneficiaries. In Pennsylvania, if we have the client, I'm going to use my mom and dad as an example. If I would name mom and dad as the trustee, and they had all their traditional powers that the trustee has, then those assets would not be protected against their creditors. But if we take the power of distribution that normally the trustee has, and that's the only thing we take from my parents, and we give it to somebody we call the trust protector. So know that's a term that we've created here at our office. And their role under the trust instrument is to make distributions to the trust beneficiaries. That's their only role. So again, normally the trustee would have that power. So we just take the trustee powers and we bifurcate them. And we say, we're going to take the power of distribution and we're going to give it to trust protector. And in my parents' case, we use my sister Jess as the trust protector. So her only job is to make distributions of the trust assets to the beneficiaries at the direction of my parents, if they would ask her to do that. So that's what a trust protector does. That's the only job they have. They don't have any other powers other than the power of distribution at the discretion. And next question is the difference in look back by Medicaid 5 years versus 1 year. So the Medicaid look back is 5 years. So whether you transfer assets in trust for your kids, or whether you transfer it to them outright, it doesn't matter. For 5 years after that transfer, those assets are available to pay for nursing home costs, meaning that Medicaid won't cover the cost of your care because you made that transfer. So it's a 5-year period that they look back on. The 1 year deals with inheritance tax. So the 5 years is the Medicaid look back. The 1 year is an inheritance tax look back. So in our example with the Woodsy family, where they transferred some real estate into the Rolling Ridge Trust number 1 and Trust number 2, if they transfer survive that by 1 year, then those assets in the trust are not subject to Pennsylvania inheritance tax. So if they survive it by 1 year, there's no inheritance tax. If they survive it by 5 years and nobody needs nursing home care, then the assets in the Rolling Ridge Trust number 1 and Trust number 2 are also protected against long-term care costs. So that's the difference between the look-back periods. Okay, Jess, let's go to our last slide, which I think is just saying that we're done. Yeah, so we made it all the way to the end. So like I said, you guys can always reach out to us. I'm Samantha from the law offices of Samantha Wolfe. Thank you so much for joining us for this month's virtual seminar. We will post it on YouTube, and we look forward to seeing you guys next month.